Hi, my name is Jennifer Schultz. I'm a partner at the Ravid Law Group in Los Angeles. We represent landlords and tenants throughout the country in their leases and other real estate transactions. Each month, we publish a Dirt Report discussing hot topics in real estate. In August 2020, we wrote about business interruption insurance and whether it covers business owners' losses during the COVID-19 pandemic. Many people may have thought that business interruption insurance covers any kind of interruption to a business, but these policies are generally limited to interruptions that are caused by physical damage to the property, such as a fire that requires the business to close in order to clean up and rebuild. The policy language generally requires a showing of direct physical loss, and the interpretation of what that phrase means will determine whether a policyholder can recover. In the wake of COVID, scores of business owners have filed business interruption claims with their insurers, seeking to recover at least some of the losses they've endured as a result of various government shutdowns and restrictions on operations. The vast majority of these claims are rejected by the insurance companies because, in their view, COVID has not caused a direct physical loss. No actual damage to the property itself can be shown, the way that it would be if there had been a hurricane or a flood. In addition, many of these policies expressly exclude claims for coverage when the loss is caused by a virus or bacteria. As a result of the rejection of their claims, many people have turned to the court system to answer the question of whether their COVID business interruptions should be covered by the business interruption insurance they've spent years paying premiums on. We've seen statistics that more than 700 lawsuits have been filed as of early August 2020. That's more than the number of business interruption lawsuits that were filed in the wake of Hurricanes Ike, Irma, Harvey, and Superstorm Sandy combined. Most of these lawsuits won't survive the initial phase, and the motions to dismiss that the insurance companies are surely filing will likely be granted. A court in Texas recently found that although there are some cases in some jurisdictions that don't require actual physical damage to property in order for a business interruption claim to succeed, that was just not the case in the Fifth Circuit's jurisprudence. Because the plaintiffs in the case, a group of barbershop owners, could not show a distinct, demonstrable physical alteration of property, their suit was dismissed. They actually didn't even claim any physical damage. Their claim focused on the loss of the property as a result of government orders prohibiting their operation. Similarly, in one of the first cases adjudicated on this subject in the era of COVID, a Michigan court dismissed a claim by a restaurant owner, also reasoning that an alteration to the physical integrity of the property must occur, and the plaintiff actually expressed that COVID was never present in the property at all. It's also worth mentioning that in both the Texas case and the Michigan case, the policies contained an exclusion from coverage for losses caused by a virus. So even if the business owners have been able to clear the hurdle of showing the appropriate physical change, their claims likely still would have been denied due to the exception clause. However, a Missouri case recently avoided dismissal, giving a glimmer of hope to other business owners hoping to prevail on the merits of their claim. In Studio 417 versus the Cincinnati Insurance Company, a group of salon owners and restaurateurs in Missouri sought recovery under their business interruption policies that cover losses resulting from accidental direct physical loss or accidental direct physical damage. The judge found that the policy's use of the word or, as in either loss or damage must occur, indicated that loss and damage are two distinct occurrences, and that direct physical damage is not necessarily required in order for there to be a loss. Therefore, the judge determined that the plaintiff's claims were sufficiently plausible to proceed to discovery. The judge took care to note that the ruling merely allows the case to move forward, and it was yet to be determined whether their claims will prevail on the merits. He further acknowledged that future case law in the COVID context may be persuasive. Two other factors in this case helped the Studio 417 plaintiffs succeed, where the Texas and Michigan plaintiffs, and presumably many others, have failed. First, in addition to the Missouri court finding that actual physical damage is not required under Missouri law in order to succeed in a business interruption claim, the Studio 417 plaintiffs claims that COVID-19 was actually physically present within their premises, in the air and on the surfaces, and it was this actual physical presence that caused their loss of use of the space and not the subsequent government orders. Second, the insurance policy in Studio 417 did not include a virus exception. Time will tell whether the Studio 417 case will actually lead to any plaintiffs receiving any money from the insurance policies, but so far they have come closer than anyone else we're aware of. Some legislation has been introduced to possibly require insurance companies to cover some of these COVID claims despite the policy language, but we'll have to wait and see if anything comes of that. Many on the insurance side fear that if they were required to cover COVID claims, the sheer volume of the claims would basically bankrupt the industry. That's it for today. Thanks for watching, and see you next month.